All right, good morning and welcome to the District of Columbia Court of Appeals. We have a full house this morning. It's good to see everyone. I know we have a number of law student interns and undergraduate interns who are here today for argument, and we appreciate your presence. We have 3 cases set this morning, joined today on the bench by Associate Judge Deal to my right and Associate Judge Howard to my left, and I'm Chief Judge Blackburn Rigsby. Our first case is Jeffrey Rice versus United States. Counsel, are you ready to proceed?
Good morning. May it please the court, Adam Thompson on behalf of the appellant Jeffrey Rice. I'd like to reserve 3 minutes of my time for rebuttal.
All right, good morning.
This court should reverse the trial court's order denying Mr. Rice immediate release under IRA. In his thorough order, Judge Kravitz was crystal clear that he was denying immediate release for 2 reasons that he discussed, not under IRA's enumerated factors 1 through 10, but under the catch-all 11th factor. Both of these reasons were improper, and indeed the government concedes error on the sufficient punishment issue. So I'll focus my argument today on the sentence disparity issue, though I'm happy to answer any questions the court has.
We'll jump in with my first question. I'm wondering if the argument may be a little bit overstated, that he only relied on 2 factors. I mean, his order is pretty comprehensive and thoughtful, and he appears to be grappling with each of the elements, the 2 primary elements, whether Mr. Rice would be a danger to himself or the community, and he concluded that he wouldn't. And that the second prong, which seemed to give him a little more difficulty, which is what is in the interest of justice in this situation. And he did look at the co-defendant and culpability as between the 2, which I'm not so sure, and I want to hear more about this, is so far out of bounds under the IRA statute as, for example, the situation we had in Doe, where the trial judge looked at a completely different sentencing scheme that we said was outside of the IRA parameters. Here, one of the factors does allow the judge to consider the other participants in the crime. And why here did he go beyond what might have been appropriate under that factor or under the catch-all factor?
So taking the court's questions in order, I think Your Honor's first question was about whether Judge Kravitz relied solely on these 2 reasons. And I think his order couldn't be more clear in that regard. On page 20 of his order, after discussing...
That's the conclusion. As he's wrapping up, he does go through each of the factors and discusses them a lot, but I'm sorry, go ahead.
I just don't see that as a conclusion at all. In fact, the conclusion section comes after that on page 20 of the order. And everything that precedes the paragraph that we focus on doesn't discuss reasons for or against immediate release.
But it does. He says there are a number of reasons that might counsel for relief under IRA. And he goes through and discusses them, his behavior, his record in prison, the fact that he does seem to be much more mature. So he does go through a number of other reasons that would weigh in favor of IRA relief.
I think the court is right that as it respects IRA relief overall, yes. The trial court discussed all of the IRA factors and came to the conclusion, after weighing in his discussion section various things, came to the conclusion on page 19 that Mr. Rice is not a danger to anyone and that the interests of justice support reducing his sentence. And then on page 20, he turns to the question of immediate release from prison and says, with that said, the court is not persuaded that Mr. Rice's immediate release from prison is in the interests of justice. And then he gives the two reasons that we've outlined. As discussed above, a reduction in sentence that would result in Mr. Rice's immediate release would cause a significant and unwarranted disproportionality with Mr. Piper's much longer sentence and would impose insufficient punishment on Mr. Rice.
I mean, the next sentence is having considered all the factors that he then kind of had walked through exhaustively. I mean, is this really load bearing to your argument, though? I mean, one thing you could say is, well, he seemed to put a lot of weight on these two factors and they were erroneous. So whatever else you put on other factors is irrelevant. So I guess I don't really see what work this debate is doing for your side. I mean, he does seem, what is he doing in all those pages where he's walking through the other factors? Why is he saying at the end of his conclusion, having considered all the factors, 37 years is the appropriate reduction? I mean, he seems to be weighing other factors. I get that it's not like he doesn't exhaustively explain exactly how they factor in, but that's a tough thing to do in IRA. You know, they're all kind of these malleable factors that you sort of say, I kind of consider this, you know, the family seems to be, the family of the deceased seems really against it. That's got to matter somewhat. IRA tells them to care about that. The government opposes, that matters somewhat. IRA tells them to care about that. What more do you want him to say, having weighed them earlier in the draft? I mean, other than I'm considering those as well.
I think that Your Honor is right that it is more important that the trial court, I think, very clearly considered these two reasons to be the most important reasons to deny immediate release. They are the only ones he mentions in the paragraph discussing immediate
Can I
release.
take you off of that argument? Say if we agree with you, but I'm not sure that I do agree that those are the only two reasons. But if we did, talk to me about the proportionality and why that is completely outside the bounds under IRA, when I think, I forget which number factor, does specifically allow a trial judge to consider other participants in the offense and other factors that are relevant. And here you have Judge Kravitz, who was the original sentencing judge, the original trial judge, and now the IRA judge, seeming to consider other factors, one of which is, you know, there are two or more participants, and of the participants, Rice was the most culpable.
So Your Honor is correct that there's factor 9 that discusses the role in the offense and the participation of other people. Here, Judge Kravitz did not cite factor 9 as a reason to deny immediate release. He directly cited his discussion that came only under factor C11, the catch-all factor of what he called an unwarranted disproportionality with Mr. Piper's much longer sentence. And then he gave Mr. Rice the exact same sentence as Mr. Piper. So it's clear that what he was concerned about was not letting Mr. Rice have a lower sentence than Mr. Piper.
So help me understand also why that's a bad thing. It seems that disparities in sentencing are something that we as a jurisdiction and jurisdictions across the country have been sincerely concerned with. He found that it was appropriate to have a reduction in sentence for the person that he seemed to feel was more culpable, the one who did the action that resulted in the actual murder. You know, why is it such an issue that he would find that a reduction is appropriate and take well more than a decade off and use this kind of proportionality that I really view as him looking at disparities in sentencing?
So two reasons there. The first is that I don't think the court needs to get into when disparities are appropriate as an IRA consideration versus not, because what happened here is that Judge Kravitz used a disparity that he cited a disparity that it was one that was directly created by the DC Council, which is to have people who are under age 25 at the time of the crime be eligible for this remedy and not those who are over age 25. His concern came in the fact that Mr. Piper is not eligible for IRA.
What if it didn't? What if Mr. Piper was IRA eligible? He had gone through his own IRA proceedings and got a sentence reduction to 30 years. Then would it be okay as to Mr. REZENE in his own IRA proceeding for the judge to say, They look the same to me, except for Mr. REZENE seems more culpable in the underlying offense. At the very least, I'm not going to give him a more lenient sentence. So I'll give him 30 years as well. Could you consider proportionality then? Or are you just worried about proportionality from an IRA, like when comparing an IRA eligible defendant to a non-IRA eligible defendant? Or even within those categories, do you think it's inappropriate to consider?
Well, I think in our brief, we have talked about how this concern with co-defendant proportionality is pretty irrelevant to IRA factors. But really, I think the core of our argument and the primary argument we make in our brief is that what Judge Kravitz did is go directly at this line of eligibility at age 25 and say, I don't agree with that essentially, and I'm going to equalize relief for these two people. So I think the court doesn't need to get to vote for us.
I would agree with you if what Judge Kravitz says is, I'm not, IRA eligible defendants should not be treated more leniently than their co-defendants. But in fact, what he seems to be saying is, well, this is quite lenient to Mr. REZENE, the far more culpable of the two. And so I am willing, despite initially sentencing to 15 years more, the leniency that IRA demands of me might extend to those 15 years, but it's not going to extend so far as to give the more culpable of the two a lighter sentence. That just goes beyond what I think the interest of justice warrant. And I don't know where IRA says you can't do that.
I think that comes from the rest of the IRA factors. So what Judge Kravitz did here undercut his analysis under, say, factor 9, for instance, which has already been brought up. In factor 9, when you look at the court's actual discussion of it, it's much more nuanced than just Mr. Rice is the most culpable for the murder. It talks about how there were other co-defendants, even beyond Mr. Piper. It talks about how Mr. Piper was the ringleader for the robberies. And as I said, it's a much more nuanced discussion that I think IRA demands. As this court said in Bryant, that factor is focused on the involvement of other people in the offense, and that is intended largely as mitigating.
But that seems to support rather than counter the notion that looking at the culpability as well as the participation of other participants is valid. And so Judge Kravitz starts the consideration looking at factor 9. And then he also revisits it as one of the other factors under the catch-all. And we are all of this analysis and discussion, I think, goes to the interest of justice prong, which Judge Kravitz seems to grapple with. And, what does it mean to consider something to be in or not within the interest of justice? And I'm still not yet persuaded that looking at proportionality between the parties involved in the offense or the parties involved in the offense, which is allowable under factor 9, would be inappropriate to look at further as a part of the interest of justice consideration and a look at the catch-all factor here. I think that what we know from the order of the trial judges, he's deeply concerned that even though the co-defendant was the ringleader, Mr. Rice, the appellant, was the sole perpetrator and turned this robbery into a murder. And he acted on his own. So I don't think Judge Kravitz is refuting or ignoring the IRA scheme of allowing more leniency for those who commit these crimes under 25. But he also recognizes some of the nuanced facts here that, he talks about Mr. Rice being almost 23 and his co-defendant, the ringleader of the robberies, being just barely 25. And so some of the disparity in age that IRA takes into account when someone's coerced by an older actor might be minimized in this circumstance because they were actually a little closer in age. So I feel like the analysis here is a little more nuanced. And again, the proportionality or the look at parties involved in the offense, I'm not seeing how that's totally outside the scheme when it's sort of baked into one of the elements of the IRA scheme. Unlike, as I mentioned, Doe, which came after this case, where you had a situation that this court determined was in fact an example of a judge applying factors and information outside of IRA when he looked at a completely different sentencing scheme that was apart from and different from IRA. That's not present here in the same way.
It's not present in perhaps the same way, but I believe it is present in the same way in a very real way, which is that so this court has settled what the interest of justice means under IRA. It means the sole content of the interest of justice comes from the IRA factors. And what Judge Kravitz did was he said, oh, well, I see C11 and I can bring in other information. And instead of focusing on it as information, the co-defendant's sentence as information, he took that and fed it into a substantive sentencing concern that he got from his own idea of what is important to the interest of justice, which is co-defendant parity. That is a sentencing factor in, say, the federal sentencing scheme. But even there, in the federal courts, when they discuss co-defendant disparities, they say, we're actually more concerned about national disparities. And there's things like the sentencing guidelines that are meant to get at disparities, but they're not really talking about co-defendant disparities. That's because there are myriad differences between people who are involved in the same offense, and that was true here. There are just myriad differences between Mr. Piper and Mr. Rice, and to limit Mr. Rice's relief to 37 years while comparing him to somebody who's not even IRA eligible, it in the same way that Doe held that considering the seriousness of the offense goes against the legislature's intent to take the nature of the offense out of the statute. This goes against the legislature's very clearly, reasonably calculated age-based line at 25. I didn't mean to interject, but I take that point. But I want to revisit something you said just a moment ago when looking at the two prongs of IRA, whether the defendant will pose a danger to themselves or the community if released, and then the interest of justice prong. And those two prongs are within the statute, and you're supposed to develop the evidence from the factors to weigh them, but it seems like they do different things, don't they? They looking at the danger to the community that the defendant themselves would pose is one thing that you use the factors to glean. But this interest of justice, to me, seems to enable the judge to take a broader look. Now that I've looked at the defendant themselves, now let me look at the impact broadly on the interest of justice of releasing this person. And why couldn't that broader interest of justice look, using the analysis of the factors, allow a broader look at the role that defendant played in the offense as compared to others in that same offense? Well, it has to be consistent with the IRA factors. And so what Judge Kravitz did here is not consistent with the IRA factors for all the reasons that we mentioned in our brief. It goes against the DC Council's intent to create this line at age 25. It goes against all the factors that make individualized circumstances mitigating. It goes against the first clause of Factor 10, which says that anybody who's under age 25 gets the categorical and unconditional benefit of diminished culpability and due to the hallmark features of youth.
But categorical and undiminished does not mean that any judge who looks at an IRA case must immediately release the defendant. We have all manner of cases where the trial judge grants significant relief that is short of immediate release.
That did happen in one case that I'm aware of, which is Welch, but in that case, the court very clearly saw that the trial court was tethered to the IRA factors. It did not step outside of the IRA factors. What Your Honor, I think is posing is that there's, for some reason, this disparity issue is not outside of IRA, but I think respectfully, it very clearly
That's
is,
what
because
I'm struggling with.
because the
You're
role
right.
in the offense in factor 9, it just doesn't speak to this. It focuses on, you know, comparing or looking to see if there is a
No,
mitigating
I like your
circumstance from.
comparing word, because I think that's in line with how I'm viewing factor 9, allowing some comparison, some look at who did what and who was involved.
And that's what Judge Kravitz did here. He did compare it under factor 9 and came out on the side of the interests of justice, support relief under IRA. And then when it came time to turn to the question of immediate release, he didn't talk about factor 9. He talked about the same concern that he had under factor 11, that he had only discussed under factor 11, which is the unfairness of the disproportionality between one IRA eligible person and one IRA ineligible person.
But
And
he
that is what-
provided relief, right? He found that the interest of justice were that some relief should be provided, and then he provided some. And I think we'll all agree that 11 allows for at least some kind of discretion. And so the question I have for you is, and I think you've mentioned this in an answer already, but I want to just be sure I'm absolutely clear on it. Your issue is not necessarily the comparison or even under 11, but the outsized role you believe it played. I believe you said earlier that it could come in as information, almost in the same way that we've held unconvicted conduct or prior convictions, et cetera, could come in at sentencing in another scenario. And so in this case, if it was just a factor and didn't seem as completely load-bearing in your view, that would not be an issue. Is that correct?
I think so. Factor 11, I'm getting the word information from the text of factor 11. I think it recognizes that the parties are going to present all manner of information to the judge, and the judge may find things that are not explicitly referenced in the other IRA factors relevant to the determination. So in the trial court, in our IRA motions, we're typically presenting things like the reentry plan, which Judge Kravitz also found relevant under factor 11. There's other BOP type records like the pattern score that don't necessarily, explicitly fall under something in factors 1 through 10. Things like social science, and the judge can find those relevant. Those are pieces of information, but what it can't do is take that information and use some substantive sentencing concern that he's gotten from somewhere else, his own mind, another statute, and use that as a factor. And here, the outsized role is important.
Can I just ask, you had earlier said that factor 9 really is sort of designed to be mitigating. And I think perhaps one salient point that you've made in your briefs, but you haven't made today, is if Mr. REZENE had acted alone and gone out there and committed this murder, there would be no floor to how much relief the judge would have given him. He could go well below 37 years. So to treat the fact that there is a second person and a ringleader as sort of capping the relief available to him under factor 9 seems to turn it on its head. Do you want to, is that part of your argument?
Yes, it's part of our argument. It's a big part of it, and I apologize for not mentioning it before, but I think it is in our briefs, and I think it raises a larger point, which is that the judge's attempt to
He's
disparity.
he's worse off than if he had acted alone.
That's right.
Right? I mean, he's worse off because the judge's going to say, well, 37 years is as low as I can go because that's what your buddy got. And if he had done it alone, that wouldn't be a consideration. And that's at least odd. One might call it perverse, but I think it's a minimum, an oddity that seems in tension with sort of how factor 9 is supposed to work. It would be, but you want to spin that out at all? Or have I said enough? I wasn't sure if you want to put some meat on those bones.
I mean, I don't know that I could say it better than Your Honor did. This is, we've certainly made the argument and continue to believe that factor 9 is meant to be mitigating, as the court said in Bryant. But I think the court said that in dicta, and this issue is sort of before the court in a different case, but
What's that case?
I'm
Okay.
not sure.
Good enough.
But I don't think our argument here depends on finding that that factor 9 is only meant to be mitigating. It just, what Judge Kravitz did here is allow his concerns under factor 11 to turn what he had already found under factor 9 on its head. And when he discusses factor 9, he's talking about all these parts of culpability that are more complicated than just Mr. Rice is the most culpable for the murder. It allows, the way that Judge Kravitz discusses factor 9, it allows for things like the fact that Mr. Rice's sentence for the robberies and the related weapons offenses consisted most of his sentence. Like more than half of his sentence, his original sentence, came from those offenses. So to find that to deny immediate release for the reason that Mr. Rice is solely responsible for the murder, it undercuts what he had already found under factor 9.
Not necessarily. I mean, the murder is pretty significant. You said the robbery offenses, there were multiple counts that he pled to, amounted to more than half. Well, that still means that the bulk of Mr. Rice's sentence was focused on the murder that he alone committed in the context of these actions. And so I'm not so sure that it's automatic. I mean, I think it's certainly a consideration whether the judge would have given him greater relief if he were acting alone, but it's not necessarily a foregone conclusion. You know, he notes that the co-defendant was sort of the ringleader of these robberies. But he's very careful to note that Mr. Rice, the appellant, committed this murder acting alone, and it was a pretty brutal one. So it's not automatic in my mind. I guess one thing I want to take you back to is what difference in terms of analysis should the trial judge place on the interest of justice versus danger to the community? They can't be doing the exact same thing. I mean, so it seems to me the factors that the trial judge weighed in favor of Mr. Rice showed clearly that he would not be a danger to the community in the trial judge's eyes. So what the interest of justice prong does seems to me is something different. It's looking at broader justice interest than just will Mr. Rice be a danger to the community. And you indicated some things that might be taken into account under that prong of the analysis, but I wonder if you could elaborate on that.
I'll try. I think the interest of justice, it's as this court has said in Doe and Riley, is defined by the IRA factors, and many of those factors speak to what is just. They speak to the diminished culpability for those who are under age 25 at the time of the offense, the hallmark features of youth, the fact that they are, and the legislative history goes to in factor 9 also to peer pressure and co-offending, and the fact that that increases dangerousness and increases the severity of offenses. All of these things are factors under the interest of justice, and they're already there in IRA. The court doesn't need to look elsewhere, and this court has said that that is error to look elsewhere for content for the interest of justice. So yes, they are different questions, dangerousness and interest of justice, but the factors that feed into them are exactly the same. And they are the ones that the council has already set forth in the statute.
All right, Mr. Thompson, I know we've taken you over your time with our questions, but you have reserved time for rebuttal as well. Thank you. Morning.
Morning, and may it please the court. Paige Lehman on behalf of the United States. The trial court here did not abuse its discretion because it considered and weighed all evidence under the enumerated IRA factors. It explained which factors and evidence the court found persuasive or not and why. And it articulated a firm factual foundation for its conclusion using all 11 enumerated factors. The appellant has not met his burden of showing that immediate release was warranted based on the victim impact statement, the government's recommendation, and Rice's role in the murder of the offense that occurred. All three of those things counseled against a finding of immediate release. The trial court accounted for all 11 factors in its analysis section. As Your Honor noted earlier, the trial court does not require to return to an explicit analysis of those factors in the concluding paragraphs, but it did refer back to all factors. In fact, the trial court focused a significant amount of time on the two aggravating factors that it added under section 11, factor 11. I believe that that was easily read because the trial court was trying to explain to this court for appellate review why those two additional factors were relevant as required under factor 11.
I mean, they don't just seem relevant. You think the judge just happened to land on 37 years, the exact sentence of the co-defendant, or you think the judge was primarily basing that sentence on using the co-defendant sentence as a floor?
So the co-defendant sentence was, I don't believe it was used as a floor. It was used more as a guidepost because when the trial court introduced the idea of this disproportionality, it was clear that it was actually looking at the culpability and the difference of that culpability between the two defendants. At the original sentencing, the trial court clearly considered that Mr. Rice was more culpable for the murder, the most serious offense. However, Mr. Rice has now this newly diminished culpability under factor 10. So the court was looking at Piper, who had less culpability during the original sentence, where he received 37 years. Here, the trial court noted that Mr. Rice has a newly diminished culpability, and that culpability is determined, a commensurate reduction may be to the originally diminished culpability of Piper as compared to Rice.
I mean, what do you think Mr. Rice would have been resentenced to had Mr. Piper's sentence been 36 years? You think it still would have been 37 or you think it would have been 36?
It could have been 37.
Could have been. What do you think?
I think it probably would have been 36 because the court was using that 36 or 37 number as a starting point to consider whether the balance of the factors weighed in favor of a further diminishment or not. The trial court.
I mean, it's at least quite peculiar, right? Because if Mr. Piper had succeeded in his own post-trial motions for resentencing and gotten, a 25-year sentence, I have very little reason to think that Mr. Rice would not have received a commensurate 25-year sentence. And something about that seems, I earlier toyed with the words odd or perverse, but it strikes me as odd or perverse, that one's sentence is going to hinge on sort of what happens, how other judges or how this judge treats somebody else. It seems hard to reconcile with IRA to me. Do you want to make me feel a little bit easier with that?
Certainly. So, Your Honor, if the trial court had considered a future resentencing of Mr. Piper, and if it had matched Rice's sentence to that lowered amount, that would have been error. However, that is not what the court did here. The court specifically mentioned the original sentence that Mr. Rice received and Mr. Piper received, and noted that that culpability difference between the two men for the offense, the murder offense, the most serious crime. The trial court noted that it was an original disparity in the sentence because Mr. Rice was more culpable. If now in the future, Mr. Piper had received some sort of reduction that would not have been under IRA, as the trial court noted, he's not eligible for IRA. It would have been through some other factor. So it wouldn't have been a diminishment of culpability per se, but some other intervening information that would have led to the trial court's consideration of that. And that would be contra to what IRA considers. It's not a distinction of culpability or a disparity in the sentence for the same reasons. Further, it's not clear that the trial court was referencing that 37 years as a floor. It's not explicit ever in the trial court's order that it would never go below 37. It just notes that at this time, based on the record before the trial court, that difference was not warranted, that Rice had not earned immediate release, or the factors did not show that a further reduction below 15 years was necessary.
You know, the government conceded error on one of the other considerations that the trial judge made under Factor 11, when the trial judge referenced or made the comment that he didn't think having served 18 years was sufficient punishment for Mr. Rice to warrant immediate release now. And the government concedes that was error because IRA specifically, the subsequent revision by the council prohibited trial judges from looking at the seriousness of the offense and the nature of the punishment or sufficiency of the punishment and seriousness of the offense as a standalone factor.
Your Honor,
Yeah, so I guess that tees up my question, which is, wasn't there a similar problem with the trial court looking at proportionality to a co-defendant who's not being resentenced or given the consideration of IRA as a standalone offense? Isn't there a similar error? Why isn't there no error on that part of it?
Yes, Your Honor. So the government does not concede that sufficiency of punishment was an improper consideration because the trial court order was explicit that it was considering that sufficiency of punishment not as a standalone factor or as an invitation to discuss a resentencing as done in Doe, Riley, or Muhammad. That was, in this case, it was specific that he was looking at the general interest of justice and the underlying principles that inform the interest of justice in the criminal justice system.
Which are what? That's what I was trying to get at with counsel for appellant. What are appropriate considerations when a judge is looking at the interest of justice prong of an IRA motion consideration?
Yes, so the most important consideration for an interest of justice analysis is definitely the continuing suffering that a victim experiences due to the offense that was committed against them. I would note that the other interests of justice that are important would definitely be the principles that support incarceration generally, such as retributive principles, deterrence, rehabilitation. Those are all not—
Those aren't explicitly spelled out in the IRA statute as is argued by your co-counsel would need to be, not co-counsel, your opposing counsel. Those concerns you just listed would need to be spelled out more explicitly within the IRA factors in order to be considered as part of the interest of justice.
The factors definitely inform how the court is to consider the interest of justice. We don't read the interest of justice analysis as being exclusive to looking at the factors. I think there are a number of interests of justice that would go beyond beyond the factors, such as things that are relevant to the factors.
Such as what?
Such as these underlying principles for incarceration generally. The American criminal justice system relies on the ideas of retribution, deterrence, and rehabilitation generally. Outside of even the IRA context, those are things that trial courts consider.
You say retribution?
Yes, as this court used the retributive principles in Welch. So those sorts of sufficiency of punishment.
Can I just nail you down on your answer to the chief's question about conceding error as to Factor 11? So the chief posited that you guys have conceded some error about considering the heinousness of the offense under Doe v. Riley. In your brief, you said the court, I'm quoting, the quote erroneously considered whether Rice was sufficiently punished under Factor 11. And then you say, but the error was harmless. So is your argument that I am misreading your brief at page 10 as a concession when in fact it is not? Or, well, yes, we conceded it in our brief, but we'd like to change our position now.
That specific quote, is a drafting error. It's in the summary of the argument. In the analysis and the actual argument that the government does later on in the brief, we do get into how it would not be error for the court to consider these general principles underlying the interest of justice. However, I recognize that that was an error and it may be erroneous. Perhaps instead, in that regard, we would argue that the error is harmless, because if the court had undertaken the analysis under the victim impact statements, as explicitly allowed in Welch, as cited in Doe, that analysis would be proper, as the victim impact statements do inform the court as to retributive principles, such as sufficiency of punishment. And here, in fact, the victim impact statements.
I'm sorry, I just want to make sure I have your answer accurate. So I think what I'm hearing is that sentence, pretty inartful, maybe a mistake, maybe we should have filed something to correct it. But if you read the brief as a whole, there's a separate section that gives what I would describe, although now I'm putting words in your mouth, as a somewhat half-hearted, not like a sort of defense, like maybe you could justify this kind of defense. And if you read those two things together, you'll know it's not really a concession. It's sort of a maybe, maybe not. Is that about right? Is that your position?
That's about my position, Your
Okay.
Honor, that it was in the analysis, the government clearly focused on harmlessness. That is, I think, a strong argument based on this court's holding in Doe. However, we do still continue to say that it was not error for the trial court to continue to consider that to begin with. If the trial court had considered that under factor 6, the trial court did give a lengthy discussion over a page for factor 6 of the statements of the victims. The trial court would have been proper to consider that as a part of factor 6. In fact, the victim impact statements here uniquely ask the court to consider the sufficiency of the punishment. All of the family members for Mr. Sennett and his friends that wrote to the court referenced some form of retributive principles. In fact, his mother, Karen Sennett, when she addressed the court over WebEx at the evidentiary hearing, she specifically asked the court to consider that Rice was on parole.
So
and that
counsel,
people-
I take your point there, but where do we draw the line on that? In Riley, we talked about not having these considerations like the seriousness of the offense and the need for just punishment. That we didn't want things not only outside of what IRA enumerates, but things that run contrary to IRA's purpose. And I think your opposing counsel makes a pretty persuasive argument that a lot of these things are more generalized principles that go away from an individualized consideration. And it really sounds like retributive principles can get to being quite a slippery slope that starts to come into conflict with our prior case law. Where do we draw the line?
Certainly, Your Honor. And the trial court here, it did cite to the language that this court has put forward that the underlying seriousness of the offense and the nature of the offense cannot take too much weight into the consideration that the trial court is doing. Here, if the trial court had perhaps considered explicitly the seriousness of the offense, that it was a murder and a series of 4 robberies that occurred, that would definitely run contra to Doe and Riley. However, that's not exactly what the trial court did here. It was specifically looking at, under factor 11, the culpability difference between the two defendants. And a diminished culpability is something that the trial court is expressly required to consider under factor 10.
So if we're looking at the culpability, and this was one of the things that was confusing me earlier in your argument, if all of a sudden we're looking at a diminished culpability, if we're looking at a diminished culpability that has been from the rehabilitative principles as opposed to the retributive ones that Mr. Rice has rehabbed himself over the years, why are we now drawing a culpability line that goes back to the original sentencing and based on someone who's not similarly situated to him? Doesn't that seem a little bit outside of the calculus in an interesting way? I'm not saying that sure that's outside of the interest of justice, but doesn't that seem to tiptoe on the line at least?
The trial court definitely considered the interest of justice analysis to be complex. It's very clear that this is an issue that does toe the line. The government posits that it does not cross that line. It stays within the bounds and it does not run against the interest and the purpose of IRA. Factor 9 does not categorically weigh in favor of the defendant, such as factor 10. In Jackson, this court held that factor 9 actually explicitly weighed against, it affirmed a trial court's finding where it weighed against the defendant. Something similar may be happening here, where the trial court held that that first clause, the defendant's role in the offense, where the defendant here, Mr. Rice, was the sole person responsible for the murder, weighed in favor of not granting immediate release, but still granting a 15-year reduction. And that second clause, the involvement of others, such as Mr. Piper, counseled perhaps in favor of some form of relief, that 15-year reduction, because Piper was the ringleader of the robberies, but he was not involved in the murder as directly as Mr. Rice, where Rice alone stabbed and cut Mr. Sennett on the sidewalk. And I also note that Rice intentionally was, or he went out that night with the intention to cut someone. That was the quote that he gave to his co-conspirators, as he stated in the record at page 31, that Rice was acting alone throughout that entire night with that purpose of committing a murder.
And so you would say that you agree that that consideration of the culpability comparatively removes this from the realm of an individualized determination, but that's okay under the statute is your view?
So this doesn't remove it from an individualized determination. The trial court was still looking at the individual characteristics of the defendant, particularly in its analysis of factors 2 and 8. The trial court was explicit that it was only looking at Mr. Rice and his history and his maturation under factor 5. To consider the
But those were
influence.
all on the dangerousness, right? Did those to you necessarily come into the interest of justice?
They certainly inform the interest of justice. It's not exclusive to the dangerousness for the history and the characteristics. I think all 11 factors weigh to either consideration, the dangerousness or the interest of justice. Here, the court was clearly grappling only with the interest of justice analysis. The court was trying to draw a line that it found was appropriate, considering on one side the victims and their extreme interest in not having Mr. Rice released whatsoever, not granting any relief with.
But does the interest of justice prong and analysis, when you say that, is that limited to in the same way to the individual characteristics of the defendant as the dangerousness prong? Or is the interest of justice something more?
So the interest of justice definitely is primarily, as the entire IRA statute is intended to look at the individual. However, we know that in society, an individual is a part of the whole. And so the interest of justice, more so than the dangerousness perhaps, does have to look to outside considerations, to members of the community who have lost a lifelong friend, a mentor in the community as a result of Mr. Rice's actions alone. If the court has no further questions, we would ask that the trial court's order be affirmed.
Great, thank you. Great, Mr. Thompson, you reserved a couple minutes for rebuttal.
So, thank you. There's been a lot of discussion about comparing culpabilities, and I just want to point out that it starts to collapse into sufficiency of punishment when you're talking about comparing the culpabilities, even under factor 9, even if that is appropriate in the way the government is discussing it, which we don't believe it is. If you're giving Mr. Rice not as low of a sentence as you otherwise would, or in other words, increasing or diminishing his relief, that because of his culpability, that's more punishment. And that is essentially the error that the court already found was error in Doe and Riley, which the government seems to be disputing directly the holdings of Doe and Riley in talking about retributive principles and sufficiency of punishment. Those things are just pretty clearly out of bounds under those holdings. So
Can I ask, I keep coming back to this point because I'm struggling with it a little, as did the trial judge here, when he's looking at how the factors inform the dangerousness prong and how the factors under IRA inform the interest of justice prong. Is the interest of justice broader than the dangerousness consideration in terms of how the judge should weigh or look at the factors?
it's not broader. It is different. It's a different question. But this, as I said before, the same factors feed into it. And I think this court will be addressing kind of on a case-by-case basis what is appropriate there. So in Welch, the court analyzed this and found that a partial grant was not an abuse of discretion. It looked at the arguments that the appellant made there and found no abuse of discretion. But there was not an error like there was here, where the court stepped outside of the IRA factors. There, the court was pretty clearly tethered to the IRA factors. So in Welch, which the government brought up a lot, and factor 6, the court didn't ask about that, but I think it is important to point out that factor 6 is not getting at what Judge Kravitz's concern was here, or else he would have discussed that as a reason for denying immediate release. Judge Kravitz's concern was with the sufficiency of the punishment and the comparing Mr. Rice's sentence to Mr. Piper's, who's not even IRA eligible. Factor 6, and as this court said in Welch, it's dicta, but we believe that it's right, is that the court is not, it would be an abuse of discretion to rely solely on that factor as a reason to deny IRA relief. And I think that's right, because factor 6 takes in.
That's the victim impact.
Yes. It implements other statutes that require victims' views to be heard. There's a value to all of that. But what the court can't do under factor 6 is use that as a loophole to get in all the things that it's not allowed to get in under Doe and Riley, which is to use that as a as a smokescreen for sort of saying, I just don't believe this person has served enough time, or I believe that they are very culpable, and so I'm going to punish them more. I think factor 6 is getting at different concerns, including the impact that the offense had, and using that kind of as a baseline for, in the same way that the other factors that the court said, touch on the nature of the offense, that can only be used as a sort of baseline for judging rehabilitation. So anyway, I don't think the court needs to get into all of that. I just wanted to briefly address that, because as I said, factor 6 and Judge Kravitz's analysis under factor 6, it just doesn't enter into his decision to not grant Mr. Rice immediate release.
So the relief you're seeking would be to immediately release Mr. Rice, or to remand to the trial court to do the IRA analysis again?
We believe that in order, an opinion stating that both of the reasons that the judge relied on here were error, and with instructions to enter a new order consistent with that opinion, either that or an order with instructions that the trial court release Mr. Rice is appropriate here, because those are the only two reasons that Judge Kravitz cited. And without that, the only decision that would be not an abuse of discretion is to release Mr. Rice.
Thank you. Was there any other questions? We'd like
No
to
further
thank
questions
both
today.
counsel for your briefs and your arguments today. Thank you. All right, our second case this morning is REZENE versus United States.
Morning, Your Honors. Nancy Allen on behalf of REZENE, and I'll reserve 3 minutes.
All right, good morning.
Morning. I'd like to start with the aiding and abetting issue that we raised in our brief, in our reply brief. There was absolutely no evidentiary basis to give the jury an aiding and abetting instruction in this case. There was no evidence at all of another person, a principal, who the assailant knowingly assisted. an essential prerequisite to the aiding and abetting instruction was missing in this case. And we'll point out on page 15 of the government's brief, the government the government notes that it requested an aiding and abetting instruction, quote, given the defense suggestion that another person was with REZENE at the time of Villatoro's shooting. That is absolutely not what the defense was. The defense was that Mr. REZENE did not do the shooting.
Yeah, but in this case, they've got Mr. REZENE in 12 other ways besides doing the shooting. They've got the text messages, the phone calls, all in quick succession, the follow-up pictures that are posted with some suggestive commentary about it. And it seems to me maybe the most rational juror would say something like, well, he did it or he set him up to do it. I can't tell which one because there's no telling who walks out of that car. But I have no reasonable doubt that he's either the principal or the aider and abetter. What's wrong with that?
Well, the first point is that there's only one person who is meeting with the decedent, one person walking into the alley with the decedent, one person running from the alley with the decedent.
You don't need to do all that to set somebody up.
Well,
You could set them up from afar. You could have your buddy go do it.
the jury's deliberation aspect then kind of intersects here with the aiding and abetting. I think they're kind of inseparable. The jury spent 9 days deliberating, sent a hung jury note, and 5.5 days later, a second hung jury note. So it was not at all clear to the jury that Mr. REZENE was implicated in this murder.
Why do you think that? Why isn't, another way of thinking of it is it just wasn't clear if he was the one who did it. They might have walked back there and said, well, he obviously is guilty of the murder as a principal or an aider and abetter, and then just been divided as to whether or not he's the one who walked out there with the gun. And so they discussed the other two charges. And that's what caught them. And that's where they got stuck. It seems just as likely as to what was going on back there.
That's where the jury's mixed verdict sort of cast doubt on the effect that the aiding and abetting instruction had, and supports our premise that the aiding and abetting instruction was the path to conviction in this case. The jury came back with a verdict of first-degree murder while armed, but acquitted Mr. REZENE of possession of a firearm during a crime of violence and felon in possession.
I agree with that. I agree that they seem to have convicted on an aiding and abetting theory, and I'm just still a little bit flummoxed as to why it would be irrational for a jury to say, well, he definitely set him up. Whether or not he pulled the trigger, I don't know.
Well, the trial court said, there's no basis to believe that there were two other individuals in some subsequent Instagram posts. There's no basis to believe that they were involved. And for an aiding and abetting instruction, this court has been clear, there has to be some evidence of someone else's involvement. And there is absolutely no evidence.
So somebody else is in the car. Two other people are in the car. And here's the cases that you're relying on all seem to be, there's one person involved. Either he's the principal or he's not involved at all. This case seems to be, well, he could be the principal, but there's also, if he wasn't the principal, he set him up and he's guilty under that theory. So I don't understand. It's not clear if this was all REZENE or REZENE did everything up until the shooting and the juror wasn't able to figure that out. But either way, he's a principal or an aider and abetter. And in the cases like that, we seem to say thumbs up to an aiding and abetting instruction.
In this case, our contention is that the government conflates presence in the car with participation in a murder, because by that same logic, all the individuals in the car with the decedent are equally culpable.
No, no, no,
of
it's
his
not,
murder.
it's not because they're in the car. It's because he's the one who sent him all the text messages to get him to that alley. And then the second that the person who walks him into the alley immediately shoots him. It's not like there was even time for a dispute to arise. It looked like an execution. And so maybe there were some unsuspecting people in the car. But REZENE, based on his cell phone data, seems to have been in the car, and he was not an unsuspecting person because he set everything up.
Would be the jury's, that would be how the jury considers whether or not Mr. REZENE was the assailant. And
Why? I mean, there's no good evidence that it's just totally unclear from the evidence who gets out of that car. You know, the best thing the government's got is this pretty, spotty video footage, and they say the clothing matches Mr. REZENE based on what he's seen wearing in this later Instagram post. It's flimsy. I could see why a juror would say, I don't know if that's the same guy, but I know REZENE was there and I know he set him up, and that's good enough.
well, our contention, Your Honor, is that there has to be something more than one person. And the government throughout the trial emphasized that this one person who got out of the car was in fact REZENE. And they talked about that's where the Instagram posts and the text messages come in. This was the principal. And then at the very end of the case, they request this aiding and abetting instruction, which our point is.
So
that
is your argument that if they had an opening statement said, we think Mr. REZENE did it, but even if he didn't, he clearly aided and abetted the execution of this murder, that would be different and we would not be arguing error, but the fact that the government at the end of their case requests an instruction for aiding and abetting made this an error?
No, it's not that particular chronology. The government, we're not basing our argument on the government's proceeding against Mr. REZENE as the principal, but our argument is that an aiding and abetting instruction has to require some evidence of somebody doing something. And the government in its rebuttal argument actually characterized this somebody as, quote, this ninja who was never captured on any of the cameras. I don't think that the court wants to say, okay, well, here's the defense. The government failed to prove REZENE was a shooter, and now the government's allowed to argue, oh, okay, well, if you don't think that, then he aided and abetted some
Well, but
unidentified.
what about the other testimony and evidence that was part of the record of other things that Mr. REZENE did? You know, the calls leading up to arranging the meeting for the purchase of, I forget whether it was drugs or guns or both in this case. That testimony and the evidence around it was significant, so that you're not just left with there's a mystery person in the car who did some mystery act. You're left with a picture that some people rode in this car with Mr. REZENE while these calls, setting this motion in place, took place. So there is more than just mere presence of another person in the car here.
All of that additional information about the texts, the posts, and all of that really do go to whether or not the jury considered Mr. REZENE the principal. Our contention is that they were struggling with that. They deliberated for 9 days and sent 2 hung jury notes. So had it been clear that our contention is they would have found him guilty, the aiding and abetting instruction gave them the opportunity then to say, well, you know what, we cannot agree on this. We can't agree what he did, but maybe he helped somebody else. But there is no evidence of somebody else.
Counsel, I mean, I want you to use your time how you want to use it. In my view, this is far from your strongest issue. Is there any other issue you want to talk about?
The jury coercion issue that we also raise, it's sort of it's interlinked with it. In this case, our contention is that the jury was pressured to reach a verdict. They in fact reached a verdict hours before they would have lost the last 2 jurors that could have deliberated.
Let's talk about those last two jurors. I mean, this trial is taking place over the holiday season, mid to late December, early January. One of the last two jurors they were afraid of losing is, I guess, the one that intrigues me more than the other. And this is the juror who indicated that they were moving to England and their visa was going to expire. But that juror also voluntarily said, well, you know, if I need to wait an extra week before I go, I can go. And the jury completed their deliberations a little before 2 in the afternoon, if my recollection is correct. And this person's flight wasn't until later that evening.
Right.
So it seems like there was a comfortable cushion there. Am I missing something? And that there wasn't any intervening communication between the time that juror said, I don't mind extending another week or so, and then the verdict, or were there some other intervening incidents?
I believe the week extension had already occurred at the time of the verdict. So the juror one had already
Right.
received that week extension. There
Right.
was no other extension.
No,
Juror-
that's the extension I'm referring to. And so they reached the verdict with a comfortable number of hours to spare, if you're assuming it was a later flight in the day, and I think that's what the record reflected. W- Where is the coercion with respect to that juror?
Well, it wasn't just juror one, it was also, and perhaps more significantly, juror 12, who raised, first of all, indicated to the court that he or she was leaving on the very next day. So that was it, could no longer deliberate, didn't give a reason, but also told the court that that he or she was having significant health issues. Specifically, the quote from the juror talking to the court, she says to the other jurors, hey, you know, watch me. If at some point I can't stand up, I can't lift my arms, my face droops, or I'm not talking to you, call and get me some help real quick. I think this court has noticed that has written some cases are just inherently coercive, and one can only imagine the pressure jurors felt when they've got these dwindling numbers. Travel plans are coming up, and they've all discussed this. Juror 5 made clear that this has been a focus of discussion. And they're asked to monitor one of their own for life-threatening illness, as the defense counsel said, to worry about juror 12 stroking out. I mean, coercion can affect sympathetic jurors, as this court has held in Morton, or jurors motivated to accommodate a colleague in distress. And one of our contentions in on the jury issue is that these people all knew about everybody's travel plans. They knew they were getting down to the wire. They were running out of time. There was attrition, and the court needs to look at this from the jurors' perspectives. The judge tried his best, you know, but it has to be viewed in context and from the perspective of the jurors.
So how do we, with the judge having to balance a number of things there, how should we consider the additional factor that in Abney, there were alternate jurors available and there weren't here? The judge was more limited in their options and took actions to accommodate both of the jurors and to assure the other jurors and push them towards reasonably considering this. It looks a little bit softer.
It was definitely softer, certainly than Abney, because except for juror 12, the court assured jurors that they could, you know, take their work trips or, you know, go on vacation.
But I'm sorry, it did?
That-
It assured jurors that it could take their work trips or go on vacation?
Juror 8 had a work trip.
Did it assure these jurors that they could
jurors.
take their trips?
The judge in this case assured juror 8 that he could take the half day.
I'm talking about jurors 1 and 12.
Oh, juror 12, he did not assure.
And juror 1.
Juror 1 was allowed to, as far as I understand, it was understood that juror 1 could go on her on her trip. However, the government did note during the course of discussions that continuing to question juror 1 was introducing an element of I don't know the word they use, not coercion exactly, but
I don't mean to interrupt your answer to Judge Howard's question, so I'll let you get going, but I will say, I don't think that's true. And so if the government has some support that the court assured juror 1 she could take her trip, I would love to hear it.
certainly the court did not assure juror 12, and juror 12 and juror 1 were the kind of the last ones standing before the verdict had to be delivered. And that's where it meshes with our aiding and abetting argument, because the verdict that was delivered makes sense. We contend it makes sense only if one looks at it as a compromise to just finish this deliberation process.
So is there any leeway, or I feel like I may have lost this point in asking a compound question. Is there any leeway or grace compared to Abney that we should be giving the trial court in this case, where there were no alternate jurors available and so it was in a tighter spot?
Well, Abney put a particular juror in a very tight spot and did not assure the juror that he could leave on his vacation. And we're just noting that certainly at least one of the jurors and possibly 2 of the jurors here were not also assured that they could.
So my question is more to, in Abney, there were alternate jurors available that could fill in, and here there weren't.
We're not.
It's not, when I was saying the tightness of the spot, the trial court itself was in a tight spot and needed to, and ultimately went with 11 jurors instead of 12, which is another issue you have that I'm not trying to push you towards, but is there some leeway, or should we be looking at this slightly different than we looked at the factual scenario in Abney, where there were alternate options available?
Well, in this, I'm not quite sure what the court is asking. In Abney, of course, there were alternate options, and that was one of the reasons the court reversed Abney. It found that, you know, it was unreasonable not to address this juror's concern, and there were alternates in that case who could have taken place. Here, there are no alternates, and that's part of our argument that the jury was under pressure just to get this over with, because the attrition had been happening. They knew about each other's plans. There was this one juror who was about to, have a stroke, and
And also, what do we make of the jury poll that came back in favor of the government, where they were asked about and indicated that their verdict was free of coercion? How do we weigh that?
It's certainly a factor that the court takes into account, the jury poll, but not in every single case has the court found that the jury poll is a decisive factor. There's no other.
I was looking at the transcript from 12/14/23, which the discussion of juror 1 who had the visa issue. And the court says, after questioning that juror back and forth, is it fair to say, I mean, the sense that I get from you, and I don't want to put words in your mouth, is that you don't sound that concerned that if necessary, you could stay another week.
Right.
And the juror says, yeah, I'm not overly concerned, but when we were talking over lunch, we realized it could be a problem. And then the court says, no, I appreciate that you brought it up. Is there anything further? And she says, no. So I don't know which way that cuts. I mean, with respect to the coerciveness issue.
Well, given that the conversation about the extra week took place before, I mean, that extra week was over and done with. So I don't know that it really is a factor in this last day after the Gallagher instruction, and when the jury was back there with the last soon to be not even enough. I mean, so I don't think that was a factor at that point. I think the coercion was happening with accumulation of things going on in the jury.
So the date that the jury's verdict is delivered is at the end of this week or so that they're talking about. And was there anything said in the record by the trial court during that week or in the day, on the day of the verdict actually being delivered that might have eased any coerciveness?
I don't believe so, Your Honor. I mean, the verdict was delivered hours before juror 1 was taking a flight to leave the country. And the day before juror 12 would be completely unavailable. And even before she was completely unavailable, she was having these health issues that were distracting and consuming to the jury.
All right. If there are no further questions, we'll reserve the remainder of your time for rebuttal.
May it please the court, Ann Park on behalf of the United States. I'd like to focus, I think, on the jury coercion issue. I think Judge Deal did a far better job of summarizing the government's position than I did in the brief in terms of aiding and abetting, and why this is entirely the appropriate context from which an aiding and abetting instruction is appropriate, when the evidence is not clear who the principal or the aider and abetter was. So if the court does not have any questions about the aiding and abetting issue, I'd move on to jury coercion.
Right.
I just want to clear up some things in the record. There were not 9 full days of deliberation, at least by the government's count. January 3rd, 2024 was the first day of deliberations. January 4th, 2024 was the second. On January 5th, 2024 was the third. And January 8th, 2024, that was the fourth day, but they had to end early because of the one of the work commitments of the juror number 8, and the court accommodated her work commitment. January 9th was the same work commitment, so they actually did not sit. And then on January 10th was the 5th day of deliberations, and that's when the second jury note came, which was really a true true deadlock instruction. The first note occurred, I'm sorry, I should have said this before, on January 5th, the third day, and that wasn't really clearly a deadlock note. They said they could not agree on the murder charge and therefore the possessory gun charges, and they wanted further instructions. So it looked like they still wanted to talk things out, hash it out. So the first real deadlock note came on January 10th, 2024, and that was day 5 of deliberations. The court read them the Gallagher instruction. The jury had not reached a verdict by the end of the day. They returned the following morning, day 6, which was the 6th day of deliberations. And they deliberated all morning, and then at 1:54, they provided a note stating that the verdict was reached, and jury was polled and nobody dissented. So by my count, it's about 5.5 days of deliberation, maybe less, because they were released early on one day. Also, Your Honors, in terms of juror 12, the health issues that she said, the court was very good. As a trial was delayed, there was an 11-day break for the holidays. There was a 1-day break because the prosecutor got COVID. There's also 1 day for the judicial conference that I didn't note in the brief, but it was December 6th or 7th. So 12 days of delay. Obviously, this caused a lot of scheduling conflicts. And at each step of the way, the trial court here, unlike the trial court in Abney, really took great pains to ask about the scheduling conflicts, to accommodate their conflicts, and also assure them not to rush their verdict because of it. And I can go through the record and point out the instances if you'd like. 12/14, juror 1, that's the first time juror 1, the juror who's emigrating to the UK, came out and said, I'm leaving on December 30th. She was informed she had an obligation to not let time pressures influence her verdict. And she answered, oh yeah, 100%. On January 3rd, the court advised juror 5, she was a juror who actually went to Portugal for a week, family trip, to not feel pressure to decide the case more quickly than she otherwise would have. And if she started to feel pressure, she should let the court know. January 4th, juror 8 tells the court that she has a work conflicts. The court assured juror 8 that she would be allowed to attend the work event, and specifically instructed juror 8 that she should not feel pressure to decide the case sooner. And if felt such pressure, she should let the court know. January fifth.
Can I just interrupt because I mean, it sounds a little artificial to me to focus on the assurance not to feel pressure when of course somebody would. So juror number one has moved her transcontinental move to England. She has pushed it back 12 days to the very last day before her visa expires. And now they're deliberating on that very day into the afternoon and saying, well, don't worry about that. What good does that do you? Here's how you can alleviate pressure. We're going to let you take your trip regardless. But don't worry about it. But I'm not going to give you any assurance that I'm not calling you back, that I'm not going to require you, perhaps via U.S. Marshal if I need to come back and deliberate. Wouldn't be the first time U.S. Marshals have tracked down a juror who didn't show up. So what good does it say? Don't worry about your red-eye flight tonight. We're going to take your time. We're going to deliberate as long as it takes.
Your Honor, I think that there's no doubt that the jury felt pressure to agree. That's inherent in every single jury deliberative process. The question in terms of coercion is, did those jurors feel forced to abandon his or her honest conviction as a pure accommodation to the majority of jurors or the court? Here, because of the actions that the trial court took, I don't think the court can say that. If you look at the timing of the verdicts as well, I don't think the court.
Then why do we say it in Abney? What was more coercive in Abney? There were alternates available. That juror might have been replaced.
The judge did not question the juror. The juror actually sent several notes indicating distress. They were worried what was going to happen to their brother if he didn't make the trip. The juror sent a note saying, "I'm going on the trip." Point blank. The judge never even questioned the juror about the trip, about whether they could, would they be able to do their job as a jury, as a juror, because of the pressure of this trip and meeting his brother. Abby was so different from here. Judge Oken, every step of the way, the reassurances that the judge provided was, don't rush your verdict because of all these time pressures.
Let me ask you, you were reading the case law definition of what we mean by coercion, that the jurors shouldn't feel a need to abandon their thought or opinion in order to reach a verdict. But isn't that what they did here? I mean, there's some, if you look at the verdict, there's some inconsistency in it. They convict Mr. REZENE of murder, but then they acquit him of the gun charge, and the murder took place with a gun. And so it seems like at the end, they're getting a little rushed, perhaps a little sloppy, and they're like, whatever, we just think he's guilty. So now let's go catch your flight. Doesn't this coercion issue dovetail a little bit with the somewhat confused verdict that is entered?
Your Honor, I think it's always dangerous to try to figure out why the jury handed down the verdict they did. I mean,
Yet we do sometimes try to figure it out.
yes, we do. I mean, we know that they didn't put him on the gun charge. It could very well be that they thought the defense counsel had kind of mucked up the record enough to undermine the government's case that Mr. REZENE was a principal. So they relied on an aiding and abetting theory, but they didn't, and aiding and abetting was not given on the gun charges. It was only given on the murder charge. So the fact that they convicted on the aiding and abetting might suggest that they were okay with the aiding and abetting for the murder, because the evidence they didn't think was clear, as Judge Gill pointed out. You see a snippet of a person's bottom half at the front seat passenger. It's just kind of hard to tell. They couldn't convict on that, so they relied on the aiding and abetting theory. That's one version. That's one way to summarize what happened. And it could possibly have been a compromise verdict too, but at this point, I think what you have to look at, Your Honor, is really was there a substantial risk of coercion? And was that coercion the kind of coercion this court is worried about when a juror honestly abandons his or her conviction? And I think with juror one, Your Honor, I don't think it was juror one was most definitely a juror who was, took her jury duty very seriously. She moved her immigration to the UK to the very last day. She took a red eye so she'd have a full day to deliberate. But that doesn't mean she felt coerced to reach a verdict. It just meant she wanted to be there and do her job. That's the kind of jurors we want. But I don't think it was ever, it's clear from the record that no one was going to make juror 1 get another visa. And
I don't know why you think that's clear. So, I mean, here's,
uh,
can I just point to how Abney distinguishes Van Dyke, right? Van Dyke, the juror gets an assurance they're going to be allowed to take their trip. Abney, the juror, is given no assurance that they're going to be allowed to take their trip. This case, neither juror is given any assurance that they're going to be allowed to take their trips. And Abney, it became coercive 3 days before the trip actually happened on January 4th. Here, this jury deliberates all the way to 2 p.m. on the night on the afternoon of the flight, and never is she told, I'm going to let you take that trip. But you're telling me it's clear that the judge would have let her. Why?
Your Honor, I would wait. He didn't say, well, first of all, I think the fact that what the judge did for every time someone had a work conflict or a trip, Juror 5, for instance, Juror 5 went to her trip on Portugal. They actually told Juror 5 in the morning of January 5th when that was her last day, I think. They told her, you are going to be able to make this trip. It doesn't matter if you reach a verdict or not. You're going to be able to take it, and you should not feel pressure to reach a verdict. And lo and behold, that day, at the end of the day, Juror 5 was released and they had not reached a verdict.
I mean,
And
can I just pause you there? Because on the beginning of the day, I actually thought it was January 4th that the juror was told that, but I could be wrong. But at least last day that before she takes her trip, she's told, I'm going to let you go and take your trip. Then your jurors 5 and 12, and the morning of your trip comes and goes and you get no assurance. And now there's no wiggle room. There's no extra jurors. There's no alternates available. I mean, why isn't the implication the judge would have told us if we were going to be allowed to go, just like he told Juror 5, but he didn't.
After Juror 5 was individually told and reassured that she could go on her trip, she had mentioned that she had talked about her trip to the other jurors. So he brought in the entire jury and he basically repeated what he said to the entire jury. She's going on a trip at the end of the day. We're going to let her go on that trip, but you shouldn't feel coerced to reach a verdict just because she's going on that trip. I think what I'm trying to say is and then Juror 8, she has a work conflict. He accommodates her, lets the other jurors know, look, Juror 8 has one of the jurors has an important work conflict. We're going to leave early and we're going to skip a day of deliberations and we're going to come back next day. What I'm saying is his conduct, his consistent conduct, his repeated assurances, both to the individual jurors and also at one time to the entire jury. The jury was watching what he was doing. And I think that would factor from their perspective whether they thought Judge Oken was not going to let them go on their trip.
I mean, I suppose I'm suggesting that it wasn't consistent conduct. He did it with the other jurors and then he didn't here. And so one natural inference, when a judge says, I'm going to let you go at the end of the day to juror number 5, and then I'm going to let you do this work trip to juror 8 at the beginning of the day. And then you get to the last day that these two are going to be in town. And there's not a word about, I'm going to make sure you take these trips. And they're very serious trips. And that's not just a missing assurance as an Abney. It is a missing assurance where an assurance has come to be expected. It makes it worse, I think.
Well, I'm just pointing out his past conduct to show that they are getting a feel for how the judge handled these things. At every point, he accommodated the schedules. I want to go through the record with Juror 1 because I understand the judge never said to Juror 1 the same way he said to Juror 5, you can go on your trip at the end of the day. But I think the record is clear by implication that no one was going to stop this juror who had already bent over backwards to accommodate the court and to fulfill her jury service as best as she could. No one was going to make her miss her trip so that she would miss her visa or pull her back from England. So let me just walk through the record. On January 8th, pages 5 to 6, there was a point where Juror 1 said she could push it off by a week. They brought her back to try to nail down or ask her how that was going. And at the time, the prosecutor thought Juror 1 at that time told the parties that I'm looking to leave around January 10th or January 11th. My drop dead day is, I think, January 12th. She has to be in England. But she didn't make it clear. Now, the prosecutor asked, so the latest you could do is a red eye on January 11th. And she said, yeah, that's about right. But she had not said that she had booked a flight. She just said 10th or 11th is the last day. And then they called her back. And this is when the prosecutor was worried that the court's decision in calling her back to question her was going to be coercive. And I think it was just basically a misunderstanding of what had happened before. That's on January 8th, 2024, transcripts pages 4 to 6. The prosecutor thought that the juror number 1 had informed everyone that she was going to take a red eye on January 11th. And then, the drop dead day was the 12th. So the prosecutor was basically saying to the court, well, we've asked her this. Why are we bringing her up again? And the court was like, well, my recollection of the event is different. I thought she said she wasn't sure it was going to be around the 10th or 11th. So I don't think it's coercive at all. I'm going to call her up. And lo and behold, it turned out, if you look at the prior record and then you look at January 8th, that the court was right. She had not definitively stated. So juror 1 told the court that day that she was leaving at 11 p.m. on January 11th. Let's see. He questioned juror 1 about what her current travel arrangements were and whether she thought those could be extended, as she had said last time, or whether she really needed to go based on her current plans. Well, he was referring to is juror 1 was floating by. She was trying to figure out possibilities of how she could go to England and come back for more jury service. And she said, well, all I have to do is touch down at Heathrow and step outside of Heathrow. That will fulfill my obligations for the work visa. And I could fly back to the United States. And then the judge was like, oh, are you kidding? Like, wouldn't that be a hardship for you? She's like, well, is it first class or business? Is it first class or economy? And everyone laughed. She was just joking. I think it was clear that no one expected her to do that. She left. The court said to the parties, I can't believe she even floated that idea by us. There's no way we would make her do that. And then, so he just wants her to confirm what her travel plans are. And at that point, she tells the court, I'm flying out on January 11th at 11 p.m. So she was available to deliberate all day on January 11th. This is at January 8th, transcript 12 to 13. And then they let her go. I think from the entire record and the transaction, and the parties, the court, they had a very good rapport with juror 1. They were very appreciative of everything she had done to accommodate this jury and to see this deliberations through. And I don't see how you can read this record and think that juror 1 thought she was coerced to reach her
Well,
verdict.
I mean, putting aside juror 12.
Sorry?
Putting aside juror 12 was a similar issue. Even if we're just talking about juror 1, remember part of the coerciveness inquiry is about what pressure that puts on her comrades to come to some agreement with her. And so it might be that juror 1 is willing to do what it takes. And she's got other jurors in there that would feel awful to make her possibly miss her flight, to make her come back from England. I mean, that is a worry that we talk about all the time. We talked about it in Abney. It is not just the coercive pressure on the juror, but it's on also the co-jurors.
I understand that, Your Honor, but I think if you look at the breadth of this record and everything Judge Oken did at each point of the way to provide reassurances, I just don't see how, from the juror's perspective, they thought that the judge was not going to let her to immigrate to the UK.
I guess this will be my last question. I know I've been battering this issue a little bit. But Judge Oken does seem to, I mean, he's aware of Abney. When he warns juror 5, when he gives juror 5 the assurance they're going to be allowed to take their trip, he does that because of Abney. He reads Abney and says, okay, I'm going to give them assurance they can take their trip. Seems to be what Abney requires. It's kind of how I read Abney. And then silence with, right? Silence with 1 and 12. I get that there, one might feel comfortable, but why shouldn't there be this is not a good driving up to New Jersey to visit my parents for a day where it's easy to reschedule. This is a transcontinental move. That's going to be a nightmare to reschedule, even though she was willing to do it once, but prior to the visa expiring. Like, why not, you know, much more serious than I think the travel in Abney, which was a camping trip with his brother.
The juror was worried that his brother wouldn't survive without him.
Well, that was his story. You don't believe that. No, but that was. I mean, yes, that is what he said. I feel some obligation to be there for my brother. It could be dangerous without me. What a hero. But you know, this is just a very serious trip, and it does seem like Abney suggests, you know, assurance would be a very good idea, and it seemed like this trial judge kind of knew that, and maybe didn't want to give it because they were gonna have to retry this case if he gave that assurance.
You know, I think my reading of the record, and maybe Your Honor disagrees, but is juror one said, I'm flying out 11 p.m. January 11th. And everyone was like, okay, because she said it definitively. No one.
But so did the juror in Abney, and that was still coercive. The juror said he was taking that trip.
Yeah, but he came back and then the verdict was rendered the very next day. Here, it was the anti-deadlock, the deadlock note came, they were instructed with the Gallagher instruction, and they actually deliberated a day and a half before they actually reached the verdict. The circumstances in Abney seemed so extreme, and the judge did absolutely nothing. Didn't call the juror up about you know, talking to him about how, you know, just did absolutely nothing. And that is not the case here. Judge Oken was active with all the jurors. I just don't see how on this entire record, and that goes to juror 12 too. I understand he didn't speak with her, but I will say on January 5th, that was a Friday, he told all the jurors, I know there are scheduling conflicts next week. And that was referring to juror 1, who was leaving on the 11th, and juror 8, the work conflict. And I'm not sure when juror 12 came. But anyway, he told, that juror 12 might have told him by that time that she had a trip on the 12th. But he said to the jury, before he excused them for the weekend, I know about these scheduling conflicts. And I understand he didn't say everyone can make them, but I think what he was saying is, I haven't forgotten about them. We will address them day by day. There was nothing that there's nothing he did that would make the jurors think that he was going to not allow them or accommodate their conflicts. He had done so for every single other juror. And that's, I think, the perspective you have to be looking at for juror 12. And I'll also note juror 12, she did have serious health issues. Everyone was willing to accommodate her. And she also said it was not going to affect her judgment and her ability to deliberate. And the judge specifically asked her that. Juror 1 also made clear that she was not in fear of losing her job. It was simply a transfer from offices. And so there's no fear of her not being able to get there and losing her job at all. She made that entirely clear too in the record. I'd also suggest the Gallagher instruction was more moderate. Judge Oken did not use the Winters instruction. The Gallagher instruction specifically says it's desirable to reach a verdict, but you shouldn't abandon your honest convictions for the majority. The language that Winters suggests is what coercion is. It specifically reminds the jurors not to do that. I would also argue that the jury poll and the timing of the verdict, that they actually deliberated for a day and a half before, or maybe a full day overall, before they reached their verdict, shows that this verdict was not coerced. If there are no further questions, the government would ask that the judgment of the Superior Court be affirmed.
Thank you. All right. Ms. Long, you reserved a few minutes for rebuttal.
Thank you.
I'm sorry, Ms. Allen. Sorry.
The trial court's efforts in this case to assure jurors not to rush the verdict are meaningless when the verdict is in fact rushed. The jurors who were told they could leave were told that before the jury had dwindled down to 11. Juror 1 and 12 were had obligations the very next day, and I think the government underestimates the effect that those obligations have on other jurors. It's not simply that juror 12, while she's afraid of having this medical emergency back in the jury room, feels like she can continue deliberating. It's also that jurors are being asked to monitor her health. The jurors are aware that juror one has to leave. That's it. This is it. Abney recognizes that practical pressures, travel plans, deadlines, concerns about the continuations of deliberations can create coercion. It's not simply that the court looks to see, that this court looks to see what the trial court did to assure jurors. This court has held a substantial risk that a verdict is coerced, where exactly in the situation that is here, the court looks at probabilities, not certainties. The analysis considers the totality of the circumstances, all the circumstances, the juror's perspective. And the court has noted that a juror that has, we're calling it 2 deadlock notes. A juror indicated that it could not reach a verdict on, I believe it was day 2 or 3 of deliberations. A juror that has reported deadlock is especially vulnerable to pressure. And what happens after the Gallagher instruction matters. There's very little time to spare. And the compromise verdict in this case, we do believe, is evidence of a juror simply wanting to get this over with, and the deliberations, and allow juror 12 to get the assistance she needs, and juror 1 to leave on her trip.
Thank you. The court appreciates counsel's briefs and your arguments today. Thank you very much.
Thank you for tolerating me, Ms. Park.
All right. Our third and final case this morning is Melvin Long versus United States. All right, counsel, are you ready to proceed?
Yes, Your Honor. Thank you. Madam Chief Judge, Associate Judges, and may it please the court. Maya Lilly appearing on behalf of the appellant, Mr. Melvin Young. Today, I'm appearing before this court as a law student permitted to practice pursuant to this court's Rule 48, and I'm accompanied by my supervising attorney, Ms. Addison Carter. May I reserve 2 minutes for rebuttal?
Which law school did you say you?
GW Law.
Okay. Yes, you can reserve the time for rebuttal. Thank you.
Thank you, Your Honor. I'm hoping to primarily focus our time today on the sufficiency of the evidence and the Brady issue. We will rest on the briefs with respect to Rule 16. However, I'm happy to answer any questions the court has with respect to Rule 16. Today, Mr. Young requests this court vacate or reverse his conviction for the following reasons. First, the government failed to provide sufficient evidence at trial that Mr. Young actually knew that he was not lawfully permitted to be inside the vehicle on October 10th. And second, the trial court failed to perform a proper Brady analysis when it failed to assess whether the disputed source documents were material and therefore subject to disclosure pursuant to Brady. Turning first to the sufficiency of the evidence. For the purpose of this appeal, the government does not dispute Mr. Young's contention that the requisite mens rea necessary to convict an individual of unlawful entry into a motor vehicle is actual knowledge. And in the government's brief and its theory at trial, it states that the evidence shows that actual knowledge can be imputed on Mr. Young because he was the only occupant in a vehicle that had, quote, extensive and obvious damage.
So I want to just ask you a little bit more about the standard. You said actual knowledge. It's not new or should have known, as it would be if we were talking about unlawful entry into a premises or building. Why is the standard greater
Sure, Your Honor.
for entry into a automobile?
So With respect to unlawful entry, appellant's position comes from the fact that the language in the UEV statute mirrors the language of the unlawful use of a vehicle statute. They both have an element which states that the individual in the vehicle may not be in there without the owner's consent with respect to UUV and without the owner's permission in a UEV case. Indeed, the trial court itself instructed itself in closing that the elements were that Mr. Young knew that he should not have been in the vehicle. And so based on the mirrored language in the UEV and the UUV statutes and the fact that this court in several cases, such as in re CAP, has stated that that language, while silent, requires actual knowledge, that's where our position comes from with respect to the.
I'm not sure I understand the answer, so let me try to rephrase it. I think what the chief's question is in the unlawful entry context, should have known that you didn't have the owner's permission to enter the premises is enough. And I think the question, or is what I'm curious about, is why would it be different as to UUV? I understand your position is that it's different, but why?
Your Honor, we were looking towards the UUV and the DC code with respect to use of motor vehicles and the criminal statutes with respect to motor vehicles.
So the answer is that because the statutes have different elements?
We see it as the statutes for UUV and UEV more closely mirror each other with respect to their elements, and therefore it is a logical conclusion to follow this court's findings that the standard for knowledge required under UEV would be similar or the same of that of UUV, which this court has stated to be actual knowledge.
But isn't UUV unauthorized use of a vehicle carry a higher penalty than unlawful entry into a vehicle? And so I guess I still struggle with why we don't have a case. This is a case of first impression, why we should apply the same standard of unauthorized use of a vehicle, more dangerous felony versus the standard of unlawful entry into property here. Because in this case, Mr. Young, Mr. Young was not driving or attempting to dangerously operate the vehicle. He was, it appeared, using it as a place to sleep or store belongings.
Yes, Your Honor. And I take Your Honor's point as I take Judge Steele's points as well. And again, I think the position really just comes from the fact that these statutes dealing with motor vehicles, and I take your point regarding the punishment being different in a use case, they mirror each other almost to a T with respect to language. And they have the same element with respect to what is necessary to show that an individual did not have the owner's consent. And additionally, I think for the purposes of this case, at the very least, because the government didn't dispute Mr. Young's position with respect to actual knowledge, even if this court does not agree with his ultimate position for this case, it doesn't necessarily need to come to an answer about the appropriate standard for actual use, since the government is not disputing our use of the actual knowledge standard in this instance with respect to Mr. Young's case. And because the government doesn't dispute that actual knowledge is necessary, the government's theory at trial, Your Honors, and in its brief before this court, was that the evidence demonstrated that Mr. Young was in a vehicle with extensive and obvious damage, which required the trial court to, or permitted the trial court to infer that a reasonable conclusion was any individual inside this vehicle would have actual knowledge that they were not lawfully permitted to be inside. The challenge, Your Honors, is that the government did not place Mr. Young inside the vehicle. And this court standard in Bynum and in re DP.
I mean, place his exact location, because the officer says that he saw Mr. Young in the vehicle when he did a first pass.
Yes, Your Honor. We're not disputing the fact that Officer Bowman testifies that Mr. Young is inside the vehicle. We're disputing, or pointing to this court rather, that Officer Bowman does not provide any testimony as to Mr. Young's exact location within the vehicle. So
This is a Kia, so it's not like it's a minivan or what do you call a mobile home. So where,
And if I could layer on. to
yeah,
Dave's question.
if he was anywhere in the Kia, it seems to me difficult that he wouldn't have seen some point of the damage, which was in different spots of the car.
Look, sure. So a couple points in response to Your Honor's point there. First, this court has stated that damage to an ignition column, specifically that it is missing, is legally significant with respect to placing this inference on someone that they do not have permission to be inside the vehicle. But what this court's case in Re DP tells us is that there has to be some evidence provided from the government that the damage is, quote, clearly visible. And so in Re DP, you have evidence introduced from the passenger compartment of a car showing a missing ignition column in that case. The evidence at trial comes out that the defendant was in the rear seat of the vehicle and exits from the rear seat of the vehicle, and that the front view of the damage is not indicative of his view from the rear seat. And so here, because we don't know where Mr. Young was in the car, and the fact that the damage would be clearly visible to him from, for example.
Counsel, I agree with you that the record is not perhaps the best record that this could be decided on, but we didn't just say that damage to the ignition column alone was the only thing. We talked about extensive damage, and in this case, there's damage all over the vehicle, including the exterior where the door handle's gone, things that are commonly indicative of a vehicle being stolen. We also have the testimony and evidence that there was a purse and a number of goods that appear to be stolen and whatnot in the back seat, which perhaps we could speculate that he was there in the back seat. But it sounds like there was a good bit of material there in the back seat. Help me with why it's so, I agree your brief is very persuasive and your argument is too, but help me why it's so cut and dry
Sure,
that
Your
your
Honor.
view is correct.
Sure, Your Honor, I'm happy to. I think with respect to the sufficiency standard, which states that we're viewing the light in favor of the government, and we make reasonable inferences on behalf of the government. There's a couple challenges with the evidence you point to. First, while it's true that there's other damage in the interior of the vehicle and several items in the back seat or in the front seat of the car, as the record demonstrates, there's nothing that demonstrates that Mr. Young first saw the back seat, because Officer Bowman testifies that after the police officers reach the end of the block and make their U-turn, at this point, Mr. Young has already exited the vehicle and he's walking away. It's not clear how Mr. Young enters the vehicle or that he was ever on the driver's side of the vehicle, because Officer Bowman doesn't supply any testimony about Mr. Young's entry into the car.
So we should make nothing as well out of his exit of the car when the police arrive?
So the government contends that Mr. Young's exit out of the vehicle constitutes flight under this court's case law, but In re DP and Agnew make clear that flight alone is not sufficient to infer a knowledge or guilty knowledge onto a defendant. Here, it's not clear that Mr. Young ever appreciated the police officers, and in fact, the police officers were noted and ticked off at the damaged door handle rather than both the occupant and the damaged door handle. They turn back around, they run the plate. Mr. Young is still walking away at this point. Mr. Young's exit from the vehicle is very different from cases such as Long and Bynum and DML cited by the government, where there's a high-speed police chase, or even in Re DP, where the individual in the rear seat opens the door and runs from the vehicle upon seeing a police officer with capital letter police on his vest. I think here there's just not enough evidence to come to even a reasonable inference that Mr. Young's exit from the vehicle is because he had an opportunity to think that the police were about to stop him.
You don't think that's a reasonable inference that when a police car drives right by you and then you exit the car that you're in and walk away, that you've noticed them?
I think
Taking all fair inferences in the government's favor, you don't think that's something that we could say, that seems pretty likely?
Yeah, Your Honor, perhaps I did overstate that that's not a reasonable inference that this court or the trial court could have made. I think the important part, though, is for the purposes of this appeal, that even if this court finds that Mr. Young's conduct rises to a level of something it would classify as flight, that flight in and of itself is not sufficient, which is where the damage is located, and the fact that there's no evidence placing Mr. Young with respect to the damage to make a reasonable inference that he could have seen any of the significant damage becomes all the more important to the outcome of this case.
We know where how Mr. Young exits the vehicle?
No, Your Honor, that's not in the
No,
record.
the officer was wearing body camera. What do we know from the body camera footage?
There's no body camera footage introduced into evidence at trial. There's also no photographic evidence introduced at trial with respect to the condition of the vehicle. And Officer Bowman doesn't provide any testimony with respect to the interior of the vehicle. That all comes a few days later when the rightful owner, Miss Brady Dennis, goes to retrieve her vehicle from the tow yard. So we find it significant that Officer Bowman only testifies about a missing door handle, nothing with respect to the shape of the interior of the vehicle. And the fact that Mr. Young cannot be placed with respect to this punched ignition is significant on these facts. And
Now,
moreover,
I mean, one sort of what strikes me as salient difference between this case and DP is there are a bunch of other people in the car, they had a bunch of other juveniles. So, you know, you can kind of see why, well, he might have thought one of them had possession of the car, and we really, unless we know who was inviting people in and who was sitting where, you know, we don't want people to be implicated just because they happen to be in a car. You know, people steal cars and invite their friends all the time. They might not know about it. Seems very different when somebody's alone in a car. And of course, you know, your client could have testified that the female companion in the area invited him in, but he didn't. There's no evidence that she invited him in. So it's just one guy in a trashed car with either he sees the back that's trashed or he's up front and should have seen the entirely removed ignition column. That all seems, I don't know, pretty good. I mean, it's sort of stronger than DP, stronger than Agnew, where there really was no visible evidence. I don't know, I guess, what do you think your best case is?
I think In re DP is closest in facts to our case. And
You want to tell me why I shouldn't care so much about how many people got out of that car in DP?
I think the point here is that the government's statement that Mr. Young is the sole occupant or in exclusive possession of the vehicle, I don't necessarily think the record states conclusively that that's the truth, because Miss Christina Pardee, testimony with respect to Miss Pardee's presence on the site can be found at pages 39 through 41 on April 14th.
She doesn't
Transcript.
say she was in the car. She doesn't say she told him to get in the car. There's no indication that she gave him apparent authority to enter this car and be in it. And we don't know any connection, and I guess this, I think, segues into the Brady issue a little bit. There's no evidence of any connection between Mr. Young and Ms. Pardo. And so that, to me, weighs into the materiality of the Brady requests by Mr. Young. Can you talk to us about that a little bit?
Materiality,
Yes.
Your Honor.
Mhm.
Sure. So before trial, it comes out that Mr. Young had requested source documents with respect to the 4 pending investigations into Officer Bowman. And the government admits that it has the source documents at trial. And the trial court goes.
And I think I'm on the wrong issue. I wanted to, I know that's one of the issues here, the source documents, but I wanted to ask you to focus on the request with respect to the contents of the vehicle.
Sure. My apologies, Your Honor. The request with respect to the contents of the vehicle was a Rule 16 request that Mr. Young made at trial. And that request really was the fact that the trial counsel was stating that the evidence was material to Mr. Young's trial defense and could not have been replicated by photographs or other types of evidence.
You still relying on that argument, or are you focusing more on the source document argument?
Focusing more on the source document
Okay.
argument with respect to Brady, Your
Okay.
Honor.
So,
But I'd be happy to answer more questions Your Honor has with respect to.
no, let's go to the source document.
Sure, okay. And to quickly just answer or discuss Judge Deal's question about Ms. Pardee's presence and the occupants of the vehicle, there are facts and evidence and testimony from Officer Bowman that after this car is found out to be stolen from police officers, Ms. Pardee receives items back from inside the vehicle, items that are said to be hers, personal items, including a purse. And so I think the fact that personal items of this woman found on scene, and Chief Judge Blackburn Rigsby, there's some testimony that the officer heard from Miss Pardee that she knew Mr. Young. It's not sure what degree of acquaintance they have with each other, but they do know each other. And so she has items in the car that are returned to her at the scene after it's discovered to be stolen. And I think that's significant for undermining the fact that Mr. Young was solely the sole occupant of this vehicle between the times that it was reported stolen and his arrest. So I think that's significant on that point with respect.
Why is that more than speculation? Couldn't he have stolen those things from her and had them in the vehicle just the same?
I do think, Your Honor, if we are treading into saying what is and what is not, the trial court actually offered that exact theory. Mr. Young could have been driving the items back to her. I do think we are venturing into speculation to say that they represent anything other than the fact that at some point she placed items in the vehicle. I think it's just as speculative.
Well, what I'm saying is not that they were in cahoots together, which I think is a perfectly reasonable read of it, but it all seems speculative. We don't have testimony from her. We don't have testimony from your client as to what the relationship was. What my question was slightly different. Why can't we just speculate along those same lines that he had actually stolen the stuff from Miss Pardee and put it in there and was about to make his way away from things?
I think, I think the standard is that the evidence has to be also a reasonable inference. And Brooks states that a conviction cannot be affirmed on speculation. And so I think to the extent that this court agrees that her appearance or presence on the scene is odd, which I think it is odd, what I'm trying to tell this court is that her items being in the car, it cuts against the government's argument that he was ever the sole occupant of this vehicle.
But under our standard of review, we have to draw every inference in favor of the verdict. And so why should we draw that counter inference that you're asking us to make, even if I don't call it speculation?
Sure, Your Honor. I think this court is entitled to infer opposite of Mr. Young's contention. I think what I'm trying to draw to this court's attention today is that the government states with conclusivity that he's the sole occupant and that her items in the vehicle present some doubt as to whether that.
Well, why is that relevant, whether he was the sole occupant? Is the other inference that we would need to make that she somehow gave him permission or authorized him to be in the vehicle?
I don't think there's enough. I don't want to overstate the record or defense counsel's position at trial. And I don't think there's enough for this court to conclude that they attempted to successfully or unsuccessfully do a mistake of fact defense. I think her presence and the items in the vehicle are just something that we want to remind this court of when assessing the evidence on behalf of Mr. Young, and the fact that the government doesn't place his location in the vehicle. They don't show where his exit was. His other conduct doesn't appear to rise to flight. And even if it does, I
So
think
it goes to, I'm trying to place this fact in terms of relevance. Your argument would be that it is relevant as a consideration as to whether he knew.
whether I think it's relevant with respect to if the government's theory is sole occupant plus clearly visible damage, it cut against their sole occupancy argument. And again, the court can make its conclusion with respect to Ms. Pardee's ultimate presence on the scene. However, we do think it is significant that items from this car were returned to her after it's found to be stolen. And so she's just someone whose presence is odd and significant for this court to note on the scene.
But sole occupant, I mean, the standard is that he knew he did not have a right to be in the vehicle. And so if we are being asked to consider that she might possibly have been an occupant, then how does that undercut the knowledge requirement or element here?
Yes, Your Honor. I think that it undercuts the knowledge requirement here just with respect. I don't know that it actually speaks much to knowledge. I actually do think we would be maybe treading into speculation to say that she gave him permission to be in the car. And I don't want to confuse the court that that's our argument today. Just more so understanding that her presence has some significance or rebuts the government's contention that he's the sole occupant. I think what's important to focus on is this court has been clear with respect to when it's appropriate to infer a guilty mind and it's clearly visible damage, and placing a vehicle with respect to that clearly visible damage. So it's our position that the government's failure to do that dooms their case with respect to providing sufficient evidence for Mr. Young's knowledge.
I thought your argument was, well, Miss Party's clearly been in and out of that vehicle. There's a decent chance he didn't know he wasn't allowed to be in there because she told him he could go in, and he didn't know that she wasn't an authorized user of the vehicle. Is that not your argument?
That is something that we state in the reply brief, but I think it is a reasonable inference to make, again, that she could have given Mr. Young permission to be in the car and that she seemed to be someone that had occupancy of the vehicle. But I also understand that that treads into looking like a mistake of fact.
Yeah, I mean, you guys could have called party, but so could the government. The government could have called party, and nobody, and it's sort of you got two people in a car and you don't know anything about them. Would you have reasonable doubt that one told the other one that they were allowed in? Maybe. I agree that, you would worry about being overly speculative. I'm not sure you should be so worried about it, though.
And Judge Deal, I take your point, and in our reply brief, we do spend some parts of our section discussing how Ms. Party's presence at the scene could lead to a reasonable inference that she gave him some form of permission to be in the car. I also do think if that is the argument here, it's significant that after items are found in a stolen vehicle, police officers find Ms. Pardee enough of an individual that they're willing to return personal items back to her from a vehicle and take no further steps to arrest her or take no further steps of her presence on the scene and what they know to be stolen. So to the extent that
It does seem rather strange, doesn't it?
Yes, Your Honor, absolutely.
Is there anything else you wanted to say about the Brady argument?
Yes, if this court doesn't mind that I spend a couple minutes on the Brady argument. The trial court's error happens where the government comes out and states that it has the source documents. It's unwilling to turn them over. The trial court in the pretrial discussion at page 16 acknowledges that the government has a duty to disclose information regarding pending investigation because under this court's jurisprudence in Martinez and Longus, we recognize that there's a form of bias that pending investigations create. With that information in hand, the trial judge skips the materiality analysis and ultimately denies Mr. Young's Brady motion. It's that skipping of the materiality step where this court should find that the trial court erred. And additionally, the government spent some time in its brief discussing why the documents ultimately are not material, but Officer Bowman's credibility was central to the government's ultimate successful conviction in this case. Officer Bowman provides the only testimony and the only evidence that Mr. Young was in this vehicle on October 10th, and the only evidence of any damage or appearance of the vehicle on the day that he was arrested. Ms. Brady Dennis's testimony occurs several days after, a few days after, at the tow yard, and therefore the trial court skipping this step, understanding that it has withheld evidence that would have been favorable to Mr. Young's preparation of the case, was error that requires this court to remand.
All right. Well, thank you. We'll reserve your time for rebuttal.
Thank you
very much.
Good morning. May it please the court, Elizabeth Gabriel on behalf of the United States. Turning first to the sufficiency argument, the evidence in this case was more than sufficient to prove Mr. Young's guilt of unlawful entry of a motor vehicle. I would like to touch first on the mens rea standard that applies. In our brief, we don't dispute, or we assume for purposes of the appeal that knowledge is required. We do think that there are substantial similarities between the offense of unlawful entry of a motor vehicle and unlawful entry on property that would counsel in favor of a new or should have known standard. There are similarities not only in the statutory language, but the conduct that is criminalized and the penalty that is imposed. And for all of those reasons, we would argue that this court should apply the standard which the court found applied to unlawful entry on property, and Ortberg to unlawful entry of a motor vehicle.
We are liberty to do that, given the language of the similarity of the language in the unlawful entry UUV statute and the unlawful entry into an automobile.
For sure, there are.
Lawful use.
Right. For sure, there are similarities between this statute and the UUV statute as well. The same similarities, also apply to the unlawful entry of property statute and the UUV statute. But the court has found it appropriate to require a higher level of mens rea, let's say, in the context of UUV. And I think that it's, as Your Honor may have suggested, because it is a felony, it requires use of the vehicle. And so there are reasons to impose a stricter standard. Here, where we're talking about a misdemeanor, where the conduct is essentially the same, it is entry into or onto property without permission, we think that the same standard applied in the UE context should apply here. But under any standard, even if we assume that actual knowledge is the standard.
Just as one, I mean,
Sure.
That wasn't briefed though. We have some argument about the similarities between unlawful entry and UUV. I don't know anything about that because that wasn't briefed either. I think you would agree with me that if we really wanted to get into this, we would need to direct supplemental briefing, and maybe it's just better to take the concession and leave it alone. Or do you think that this is fairly before the court, sort of a reason, a negligence standard? Do you think that's fairly before us to consider?
Well, we don't think it was briefed by appellant. Appellant didn't press or raise the issue of mens rea in those terms, asking the court to find the appropriate standard. But we don't think the court necessarily needs to reach that in this case. If the court wishes supplemental briefing, of course, we would comply with that. But in this case, and the trial court here did apply the actual knowledge standard, we do think that there was ample evidence that satisfied that standard. So turning to what the evidence was, we think that viewing the evidence in the light most favorable to the government, which this court is required to do, the question is whether the evidence supported a reasonable inference of guilty knowledge. And on these facts, where Mr. Young was the sole occupant of the car, with damage not only to the outside of the car, the missing door handle, the completely missing ignition column, and the extensive damage to the interior of the car, it was completely trashed. We think that any rational fact finder could conclude that Mr. Young knew that he did not have permission to be inside the car. And coupled with his behavior, of course, upon the approach of the police. Once the police approach, he gets out and he distances himself from the car. I think that, I do want to clarify that their appellant suggests that there was no body-worn camera footage admitted at trial. There actually was in the defense case. And from that footage, you can see a view of the interior of the car from the trunk, which shows, and this is a Kia, as Your Honor noted, it's a small car. It is a small hatchback vehicle. And the view that's shown on the body-worn camera, you can see from the trunk directly into the driver's seat. Given that Mr. Young was the only person in this car, we think it is reasonable to infer that he had to have seen that damage. He had to have known that the ignition was missing and that there was further damage in the car. And that's what makes this different from in Ray DP. In Ray DP, there were several people in the car. The defendant was one of many people in the back seat. And the only damage that this court noted was the punched ignition. In fact, in Ray DP, the court made a point of pointing out that there was no other visible damage. That is an incredibly important distinction in this case that makes it.
There are other distinctions that cut against you, such as I think the car in that case had been stolen just a couple of hours earlier. 4 people truly fled from the car. There's a pretty powerful dissent in Ray DP saying, pointing some of those things out that are absent here. So what about, this has been several days, right, before this person's found in the car. I mean, leading to a stronger inference that it might not be the people that stole it. Somebody else might just be using the car and thinking they have somebody's permission to do that.
Well, it was 3 days.
Yeah.
Yes, there was a 3-day time period. But But the dissent in Ray DP, we think actually strongly supports our case. The dissent makes the point that while none of the factors in Ray DP in isolation may have amounted to sufficient evidence, viewing the totality of the evidence the evidence did support conviction in that case. And we think that this court ought to view the totality of the evidence. Flight alone was not enough, but considering the total picture here, where you've got, you know, all of this damage to the car is trashed, and then as the police approach, the defendant immediately exits the car.
I definitely, I agree that the dissent supports you. I mean, the dissent lost that fight. And I guess what I'm saying, I take your point that the majority did point out there was no other damage to the car. You know, as somebody who has 3 kids, I don't know how much damage to a car is indicative of it being stolen, but I'll just cede the point that maybe it does. It just seems that there are some countervailing things that were more incriminating than DP that might offset that. So, you know, I'm not sure I'm not sure that the scales here weigh heavier in favor of a conviction that they didn't DP. Because, you know, the dissent had a lot of good arguments for why that should have been upheld too.
As someone who also has 3 kids, I can say that if one were to see the backseat of my minivan, you might think it was stolen as well. But there was damage to the car in this case that was correlated with stolen vehicles, right? We have the missing door handle. We have the completely missing ignition column. The seats are torn up. The fabric is torn up. Those are indications that whatever is going on with that car, you don't have permission to be inside it.
Was the body cam footage admitted as an exhibit to the briefing on appeal
It was not.
by either party?
By either party. We're happy to supplement the record on appeal with that if the court wishes to view it. But we do think that once you see that footage, it is very clear that this is a small car and that the view from the back to the front of the car is pretty clear. And that supports, of course, the conviction in this case.
I want to address the Brady violation issue.
Yes. Mr. Young has not carried his burden of establishing a Brady violation in this case. He has not shown that the source material, that any of the government's disclosures raised a red flag or potentially implicated material that was of impeaching or exculpatory value. And it was his burden to do so. He essentially asked for disclosure of material so that he could dig through the material and find any evidence that might be useful. That kind of fishing expedition.
The rules allow for that, or for the court to review it in camera.
The court may review material in camera if the defendant makes a sufficient showing of a reasonable basis to believe that there is material that is favorable that hasn't been disclosed.
Here, I mean, typically bias is something that could be potentially material. And what the appellants were trying to show is that because the officer here had some, were the infractions and had been was the subject of a number of investigations about his conduct. Why wouldn't that be material to any potential bias?
Well, there's no reason to believe that the investigations that he had for use of force, I mean, we're talking about 4 investigations. 3 were for use of force. 1 was for a failure to render medical assistance. Nothing in the disclosures, and the government did make ample disclosure about the nature of those investigations. Nothing.
The government's argument that they're irrelevant to this because this was a property offense or a misdemeanor? What was the government's response to
those investigations would have been relevant if they, for example, suggested a reason to question the veracity of the officer or suggested that there was corruption. And nothing in those investigations, the nature of those investigations did not suggest that there was such evidence. The fact that an officer is being investigated for use of force doesn't mean that he is not credible or that he's done something of a corrupt nature.
We don't know how because I understand you to be saying that the government made this argument, but we don't know what the trial judge based their decision to deny the request on, because there's no clear discussion about whether the trial judge thought it was immaterial, not immoral, irrelevant, and if so, why? Is that a basis for finding error?
No, Your Honor, the burden is on the defendant to make a proffer that would require a further look by the trial court. Short of that, absent such a proffer, it is the government's duty and obligation to review material and make disclosure. And the Supreme Court recognized in Pennsylvania versus Ritchie that the government's say is final unless there is some further showing, some further proffer that would raise a red flag or cause the court to question that disclosure. And so, again, it is the defense's burden to point to something. And we can imagine cases where the defense could do so. Look, this officer is being investigated for fraud, let's say, or there's been a sustained finding, an adverse finding. Okay, that might satisfy their burden, but here nothing, short of conjecture here. I mean, the defense position was basically that there may be something in there, and that's simply not enough to satisfy their burden.
Let me ask you, along those lines, point they're making is the trial court skipped the materiality review, and assuming that it could even get there, I was looking through the record. Am I wrong in failing to see a request for an in-camera review?
No, the defense didn't request one, and that's why we argue in our brief that that claim now should be on plain error review. On this record, there is no plain error. There's no error at all, much less plain error, because an adequate proffer was not made. If there are no further questions, we would ask this court to affirm the judgment below. Thank you.
All right, thank you. Ms. Lilly, you reserved a few minutes for rebuttal.
Thank you, Your Honors. A few responsive points on rebuttal. First, page 7 of our initial brief discusses the mens rea with respect to unlawful entry and the fact that this court has not answered that question. So I think we did pose a dispute with respect to what the proper mens rea is, and therefore the government's decision not to dispute our contention with respect to actual knowledge should control the court's review in this case. Second, with respect to the body-worn camera footage, discussion of this begins at page 44 of the April 14th transcript.
I ask you if the standard were knew or should have known, would the outcome be different? Would the government have satisfied its burden under that lesser standard?
I still think, Your Honor, it's challenging to say that there's an inference imputed on Mr. Young with respect to any damage on the vehicle, because we don't know where he was inside and his exit. And so to the extent that the theory of knowledge is supplied by the type of damage and relying on the fact that the damage is what supplies the mens rea, I don't think there's enough to say that Mr. Young knew. He also was only in the vehicle for a short period of time. The officers are driving to the end of the street.
You mean the officers only observe him in the?
Well, yes. The record reflects that he's only in the vehicle for a short.
Do you disagree with your opposing counsel's statement that the vehicle, which I understand to be a Sportage, which is a compact SUV, similar to a hatchback, that you could readily see even from the back end with a very small window, like the front?
I think you'd need a photograph to at least come to that reasonable inference or conclusion with respect to what could be seen from the back. And to just quickly piggyback off Judge Howard, your point, the body-worn camera footage was not admitted into evidence. The trial judge specifically asks defense counsel what the purpose is, and it's to refresh recollection or to impeach. It's ultimately not admitted into evidence, so it wouldn't be appropriate to supplement the record with. In respect to the Brady argument, I think it's important to distinguish between what type of cross-examination Mr. Young was trying to pursue with respect to the investigations. This court has made clear in its Sixth Amendment precedent that the confrontation right is the extent of the bias must also be able to be shown on cross. And this specific type of bias, this court said, this pending investigation bias, relies inherently on the fact that the investigation is pending. The officer's subjective belief about a pending investigation is what creates that motive to curry favor. And so I think in Vaughn and in Augers and in Wilson, the court is focusing on attempts by defense counsel to cross-examine for prior bad act without a criminal conviction.
So
That
you knew that at trial, you knew that the investigations were pending.
Yeah.
I understand you weren't trial counsel, but what other information do you need from there to question the defendant or question the officer about that?
Sure, Your Honor. So I think in footnote 24 of Vaughn and in this court's Miller case in 2011, it states that favorability and the use of favorable information when being assessed by the government before trial is looking at the opportunity for a reasonable lawyer to use that in investigation and trial strategy. That was specifically cited by trial counsel in the record about how they hoped to use this pending investigation information. And furthermore, we're not accusing the government in this instance of any bad faith, but we do think that Vaughn demonstrates that summaries can sometimes be incomplete, that they don't always show the full picture of what is going on underlying. In Vaughn specifically, there was a use of force investigation into that officer witness, and the underlying information, the source document materials, showed that that was where the witness's veracity came into issue. And so it's not necessarily a fishing expedition when unfortunately we've had cases like Vaughn, and that is what Mr. Young was concerned about and hoping to investigate and use in his trial
What
strategy.
do we make of the fact that trial counsel did not request the court to review the source documents in camera?
Yes, Your Honor, that is definitely something that poses some sort of an issue. And I don't want the heart of Mr. Young's argument on appeal to be that we were seeking in-camera review necessarily. What we're saying is that we filed a motion that there was a potential Brady violation in this case. And we offered to the court that there are being documents currently withheld from Mr. Young's trial team. And the court recognizes specifically that they would have a favorable use to Mr. Young because they could be used for that pending investigation bias. I think at that point, there was enough basis for the trial court to ask more information of the government. And we offered in-camera review because in Vaughn, that's how the court performed its materiality analysis. And we see that as the natural type of manner, but it's not Mr. Young's attempt to try and control the trial court. What we're mostly saying is that this court said in Smith that the trial court abuses its discretion when it makes decision without properly informing itself. And that's the basis, that's the heart of the error here, that there was a denial of the Brady claim without informing itself of what was in those documents to say that there was no violation happening. For the foregoing reasons, we respectfully request this court vacate or reverse Mr. Young's conviction. Thank you.
Thank you. We'll take the matter under advisement, and the court wishes to thank both counsel for your briefs and arguments. And just take note that the court appreciates the student advocate here. You did an excellent job with the oral argument, and we appreciate her faculty and support of her during this argument, and the U.S. Attorney as well. Thank you both.